a very good day to all the students for this particular session, and welcome to this session, a special session on something which would be quite appropriate and new to most of us across various disciplines. We are going to talk today about understanding an intellectual property, primarily the copyrights, and how to manage this issue of a legal protection on some of our own research outputs faced today universally across the world, particularly on academic fora. I thought we will try to have this session by understanding the very basic meaning and concept of intellectual property, particularly with respect to the copyright laws, understand what is this copyright infringement which is seeping across all academic platforms, and the new emerging issue of plagiarism. Also try and see if there are remedies in this law, and understand how to deal with plagiarism in our own forte. So, friends, when we are talking about intellectual property, conceptually it is anything, a legal connotation to something which comes and emerges out of our brain, a tangible form of a creation which comes out of the intellectual power of a person, when given a legal status, becomes a property, and a property which defines certain boundaries and rights on the person who is holding it. I am sure you will all agree that this also gives recognition to the creators, which is very, very important, which is important to motivate them to create some more innovations. Intellectual property is of different forms, and if you will see in this slide, there are several forms. After all, you can have an invention which is given under the law a connotation called patents. You can have lot of three-dimensional forms of intellectual contribution in form of designs. You can also have some distinctive ways of trying to understand and brand the product which is in the market. For example, if you were to see this particular slide, there is a format of open educational resources. There is a format which defines why is it, for which course, and this itself, I would call it the way to sort of brand the product which we are taking. You would see in the markets several products which are actually identified by the consumers by their trademarks, and that is one form of another form of intellectual property. We do have in India a method to protect plant varieties, rather I would say register plant varieties. We also have another form of intellectual property which is restricted to ICs, the integrated circuits, which form the base for some of our fuzzy logic based products in the consumer markets. There is also another provision for communities to be accorded rights if there are certain commodities which are strongly linked and are found to be sort of associated with the geography of the markets they are actually coming from. To the markets they go. And the last I was saying, which is the topic we are going to really discuss more in detail, is copyrights. Copyrights is another form of a type of intellectual property which is closely associated with creation. So, let us understand that what is this copyright. Before that, before understanding the concept of copyright, let me also tell you each of these IPs which we saw in the previous slide are also having a statute in place, the laws which have been amended post TRIPS era as per the accords and agreements the country had at the World Trade Organization. And over this last few years, India has become TRIPS compliant in form of amending all its acts, including the Copyright Act, which we are going to really focus on today. So, having said this, let us understand what is this copyright and how is it so important for an academician like you and me. Copyrights are given a legal rights or of intellectual property which tend to protect creativity and ingenuity. The creativity emanating from brain power. It is all sorts of, now you and me can have lot of creativity in our own brain, but it's only given a protection when it comes down as a tangible product. That is, it can be a publication, it can be a literary content, any literary work. It can be a poem, a story, an academic research paper, a book, anything. It can be also artistic expression, which include of course paintings and other the more sophisticated technology based photography, videography, sound recordings, and of course the real time material which is quite often unpublished but very, very important in our academic daily life, like maps, and of course technical drawings which form the base for several of our experimentation and methodology. And in today's world where IT is really governing, it is important that databases are important links in our research. Even databases are regarded legally as expression of one's idea of organizing these elements in a database, and databases are also accorded copyrights as per the Indian law. So, what are we trying to protect? We are trying to protect the arrangement of words, we are trying to protect the connotations of music notes, the way we express the color and shapes in a particular fashion for any product. We also try to have auxiliaries in form of sound recordings and other audio elements. So, in other words, friends, copyright protects the original form of creation. I have said authorship, but it means authorship in a broader sense, fixed in for any tangible medium of expression, original expression, mark my words, which is now known or later developed from where they were perceived. So, one can have a lot of ideas expressed in form of a tangible original product or any form can be accorded a copyright as per the laws. Now, I said copyright is an intellectual property. Unfortunately, every right has a term. Unlike the property which we own, physical property which we own at back home, intellectual properties have a set term of operation. In case of copyright, in the days before TRIPS, it was limited to about 25 years in most countries. But Indian laws, for example, are supposed to be TRIPS plus. That means most literary, dramatic, musical and artistic works are accorded a term, and a long term, much more than even 25 years, much more than 50 years, which is now the rule as per the TRIPS agreement. In India, as per our law, we give lifetime of the author and 60 years from the beginning of the calendar year next following the year when the author dies. That is a long time for any rights to be, which I'll mark my words, they are also inherited. They are also passed to the legally identified inheritors. Apart from this, all the other works which have been listed here, including government work and all, which are accorded copyright, the term stands for about 60 years. That is 10 years more than what TRIPS has afforded for member countries. One more thing you would like to say, if I were to get a copyright in my country, will that right work in other countries? And since our country is a part of an international agreement, the copyrights of other countries as well as the copyrights of works from India are protected in India, and reciprocal rights given to Indians across the globe. So, this is definitely a departure from the earlier, and the fear that my works which are protected in one country are recognized by others also is of course dismissed. Now, if I were to apply for a copyright, let me also clarify to all of you, in India, the day you have a tangible expression of your original expression of your ideas, that is a paper or a book, the copyrights are already there. Remember, all of you, whenever we are trying to type in the using the computer, we do see a small little word which is C and has an enclosure, which indicates you can put it. However, if there were to be a legal tangle, and I really hope none of you face it, you need to have a certificate and a registration done in a statutory office to go ahead to prove that somebody has copied yours. And that statutory office in India, under the section 9 of the Act, is the Copyright Office, which is headed by a very, very able designated authority, the Registrar of the Copyrights, and it's currently centrally located in the national capital. The way the copyright is actually applied, everything is indicated in a very transparent way in the website, which was already cited in the previous slide. So, now till now we have understood the concept of copyright, where it is actually identified to the forms under copyright. And as a scientist, if I were an academician, I again reiterate, copyrights are for anything which is coming in from flow from our research activities in form of books, in printed material, in form of your rights which come as an author for the numerous number of papers. It can also come for any of these articles which you write in popular. So, there is no limit that it should be only an academic work printed in a formal publisher. Anything emerging out of your brain in a tangible form, of course, including dramatics, the way we speak, if it is a recorded, a sort of a recording of the way we are conducting a class, and which is actually has commercial value, even that is accorded a copyright. So, as a person in academics, I am just trying to reiterate the forms which we have. If that being said, I think we have now reached stage where we need to understand what is this infringement. And I am sure as young students of this course, many of you would have heard this word infringement. As per the law, infringement, you have an ownership of certain IP, and there is a boundary within which a holder is operating. So, anybody without taking appropriate permission of the owner who has been granted the copyright is definitely infringing if he uses it, or if he is using it in contravention of the conditions of the license with which he has an agreement with the owner. Both are important. infringement without knowing and copying it just because you like it, or infringement after having known and then copying it or using it for commercial gains within the operation of the license is also in case of infringement. And it is definitely important that all of us understand the whole gamut of infringement, especially when we are all working in a public sector environment or any organization for that matter. Knowing about infringement need not be so scary. There are a lot of exceptions, especially for academics. And please understand, under the fair dealing clause of the Indian copyright, all these three conditions are exempted, are reasons for exemptions for an infringement case. There are also, if there are proved infringements, there are three types of remedies, and let me also reiterate, the remedies under the Indian law are very, very strong. Three types: administrative, civil and criminal. Criminal, which is pretty harsh in terms of the fine, which is as high as almost 2 lakhs, which is also shows the determination of the entire government to deal with it. Now, we have talked about infringement, but we need to understand that is another important word which should be really understood, that is plagiarism. Between both these terms, while infringement is a violation of the rights, plagiarism is there is no question of rights, it is a practice, very unethical, immoral activity, unprofessional activity, which clearly amounts to academic dishonesty, particularly taking somebody's ideas and passing them off as their own. There are a lot and a wide range of plagiarism which can be deliberate in intention to accidental and also unknowing. For this, the only way to curb would be an institutional policy. Friends, it is already known that all higher education institutions in India are adopted or have to adopt policies for curbing and checking. And under the, particularly under the UGC regulations which came out in 2018, it is mandatory to use software to check before submission of dissertations, because any case of plagiarism is not only the responsibility and it can harm the student or the writer, it can also be the faculty associated with this. And I think it is important that all of us involved, be it a faculty, student, library professional, all of them have to be sensitized through this several awareness program, and in a long term inculcate a change in the mindset to discourage plagiarism in organizations. So, let us take one at least as a last part, make a rule book for all our institutions. As a rule, only use own ideas and words. While using others' material, learn to give credit for copying, adaptation or even paraphrased material, even because that is also a case of plagiarism. Avoid using others' work with minor changes, and most important, learn to cite and give attribution to others' work. I think if that is a habit in our academic writings and research, I think everything else is sorted out by its own. Thank you.